No kidding. Let's do this as we can.
Are you ready? Yeah. All right. All right, thank you all. We're going to get started in a minute here. Good afternoon. Thank you all for being here. My name is Jacob Charles. I'm the Executive Director of the Center for Firearms Law here at Duke Law School. I want to thank you all for being here. October is Domestic Violence Awareness Month, as you may or may not be aware. We're thrilled to have an exciting panel discussing this important issue today on domestic violence and the role of firearms in those incidents. I want to, before we get started and turn it over to our panelists today, thank our co-sponsors for the event. So the Center for Firearms Law sponsors the event, and it's also part of the Human Rights and Practice series organized by Duke's International Human Rights Clinic and the Center for International and Comparative Law. The co-sponsors for the event are many, and we thank them. They are the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Human Rights Center at the Keenan Institute for Ethics, the Coalition Against Gendered Violence, the Human Rights Law Society, the International Law Society, and the Women Law Students Association. Thank you.
Thanks, Jake. I'm really excited to be moderating this panel. Just for those of you that don't know who I am, my name is Darrell Miller. I'm the Melvin G. Shimm Professor of Law here at Duke and one of the faculty co-directors of the center. And this is obviously a really timely, sort of evergreen issue about the intersection of firearms and domestic violence. And I'm really delighted to have this excellent panel together to talk about this issue. I'm going to introduce you to the panelists. They're going to spend about 15 minutes or so making some remarks, and then we'll open up the floor to questions and hopefully have a sort of robust discussion here. So in order of speaking, to my immediate right is, my right, your left, is Sherry Honeycutt Everett. She is the Legal and Policy Director of the North Carolina Coalition Against Domestic Violence. She's a native of North Carolina with over 10 years' experience litigating on behalf of survivors of domestic violence and sexual assault. She holds a JD from the University of North Carolina at Chapel Hill, as well as a Master of Arts in Teaching and a BA in History and Women's Studies from UNC Chapel Hill. And prior to serving with the coalition, Sherry worked on behalf of survivors in both private practice and nonprofit legal sectors, and has experience serving on councils and other committees and task force dedicated to improving the lives of survivors of domestic violence. To her right is my good friend and former colleague, Dean Verna Williams. Dean Williams is the Dean and Nippert Professor of Law at the University of Cincinnati College of Law. Before joining the College of Law, Dean Williams was Vice President and Director of Educational Opportunities at the National Women's Law Center, where she focused on issues of gender equity and education. During her time at the center, she was lead counsel and successfully argued before the United States Supreme Court of the United States, the United States Supreme Court in the 1999 case of Davis versus Monroe County Board of Education, which some of you are interested in education law might have read. She argued that case, which established that educational institutions have an obligation to respond and address complaints of student-to-student sexual harassment. She's a cum laude graduate of Harvard Law School and a graduate of Georgetown. Our final speaker is Aya Fujimura-Fanselow. She is the Senior Lecturing Fellow and Supervising Attorney here at Duke in the International Human Rights Clinic. Prior to joining Duke in fall of 2017, she had developed extensive expertise in the human rights area of advocacy, clinical teaching, fact-finding, research, and litigation within the United States and abroad. Her work has primarily focused on gender and human rights, as well as economic, social, and cultural rights, transitional justice, reproductive rights, and criminal justice with a focus on pretrial detention. She's a graduate of Fordham Law School and Bryn Mawr College. And with that, I'll begin with the panelists.
Yeah, thank you, Darrell. Well, I'd like to thank Duke for hosting this panel and for caring about this issue. I really am happy to be here and happy to talk to you all more about this work that I do every day. At the Coalition, we are a statewide agency. So we're located in Durham, but we are actually the domestic violence agency that is charged with looking at this issue from all sides across the state of North Carolina. And my role there as the Legal and Policy Director includes, among some other things, being our lobbyist to the North Carolina General Assembly. So I'm going to talk to you a little bit today about North Carolina state firearms law, although I know we're looking at this from an international human rights perspective. We also know that the actual mechanics of owning, possessing, and purchasing firearms are governed largely by state law. So I'd like to talk to you a little bit about what things look like in the state of North Carolina for victims of domestic violence when it comes to firearms. And then I'll start with some statistics. Then I'm going to talk to you a little bit about what's happened recently in the area of firearms law in our state, and then end with some action steps that I think we should be taking here in North Carolina. And then I think my colleagues on the panel here are going to expand out into a more broader view, more international and national view, as I understand it. So starting first with North Carolina, why is it that we care so deeply about this? What specific risks are there for domestic violence victims when firearms are involved? Well, we know that the numbers are staggering. The chances that a domestic violence victim will become a homicide victim increase by about 5 times if there is a firearm present in the home. We also know we're tracking at the coalition the numbers of domestic violence homicides and what weapons were used. And over a 10-year period between 2004 and 2014, there were 284 domestic violence murder-suicides in our state. 98% of those involved a firearm in at least one of the 2 deaths. So this is a very particular area of concern for us at the coalition as we look for ways to decrease risk and increase safety for victims of domestic violence. Unfortunately, over the last few years in our state, there's some important protections for domestic violence victims which have been eroded. And so I'm going to tell you about that in both the criminal sort of area and also the civil area of law, the ways in which some of these protections for victims of domestic violence are actually decreasing. So we know from a really great study by Michael Siegel that when we have state domestic violence laws that cause perpetrators of domestic violence to surrender and prevent them from possessing firearms, we know that homicide rates go down by about 14%. So in states where those laws exist and are strong, we know that there are 14% fewer homicides. For that reason, at the coalition, we're really concerned with how we strengthen and how we maintain those protections in our state's domestic violence codes. And so, unfortunately, in 2015, we had a state case, Stansel versus Stansel. And what happened, in a nutshell, I won't get too into the weeds of the legal technicalities, but in our state's domestic violence restraining order statute, we have 4 instances in which prior to the Stansel case, we had interpreted our statute as requiring surrender of firearms and that a defendant not possess them. And those 4 cases were the use or threatened use of a deadly weapon or the pattern of a use or threatened use, threats to seriously injure or kill the aggrieved party, threats to commit suicide by the defendant, and serious injuries that were inflicted on the victim. In the Stansel case, what actually happened is the Court of Appeals said these are the only times that a judge is allowed to order the surrender of firearms. And those 4 high-risk factors did not include a range of behaviors that we know are very high risk that increase the chances of a victim's lethality, including the biggest one I can think of is strangulation. We know that strangulation often does not leave visible injury. So that category there of causing serious bodily injuries is not necessarily covered by that factor. And so after the Stansel case came out, judges across the state began saying, well, none of these 4 factors are present, therefore we cannot order that this defendant surrender their firearms. And in fact, that has been tested a couple of times since the Stansel case in 2015, and it is the fact that this is the law in North Carolina. So at the coalition, we included in this year's legislative long session on our legislative agenda the goal of trying to correct for that outcome in Stansel and to restore a judge's discretion to remove firearms and additional factors besides those 4 that were listed. And we did get a sponsor and we did run that through the legislature. But the thing that happened is the thing that very often happens, which is that it becomes a very heavily polarized political issue. And so when I spoke at our Judiciary Committee meeting on this law, it quickly became highly partisan and quickly became a debate between the Republicans and the Democrats in the judiciary about taking our guns away and Second Amendment rights. And so that vote was taken. It didn't get out of committee. It actually was 13-14, went straight party lines, and we were not successful in making that change and correcting for Stansel. So that's a problem that we still have in our state law on the civil side of things. On the criminal side of things, we also have an issue that needs to be resolved, which is federal firearms law prohibits someone who has been convicted of a crime of domestic violence, a misdemeanor crime of domestic violence, from possessing a firearm. But the definition of the crime of domestic violence includes the use of physical force. And the problem in North Carolina with that is that our misdemeanor assault statutes include the potential for someone to be convicted from behaviors that come from a state of mind that's culpable negligence. And so because that is not actual willful force, the United States Supreme Court has said that our statutes are not in the category of misdemeanor offenses that are crimes of force for purposes of preventing a defendant from possessing a firearm under federal code. So those are two very North Carolina specific issues that we currently have, and different groups of folks and agencies have been looking at ways to correct for those. But the truth is, despite the fact that we try our best to frame this as an issue of protections for victims of domestic violence, and we are very careful about making sure that we have the best research and statistics as we go about talking to legislators, the truth is it becomes very political very quickly. And we also know that a lot of times statistics are just not persuasive for people who feel very strongly about firearms related and gun control rights. And even, we had House Bill 454, which was introduced earlier in this session. And following the 3 mass shootings that we had over a period of 8 days, there was a group of legislators who tried really hard to get that out of committee and onto the floor for a vote, but the House leadership simply wouldn't move that bill, even in the face of a lot of public support. It still didn't go anywhere, and that's, our legislators see themselves as very beholden to their constituents who across North Carolina are extremely passionate about their Second Amendment rights. And so with all of that said, I think that, going forward, what the coalition's position on firearms remains and continues to be is that we are looking at this through a victim's rights, survivors' rights framework. How can we reduce risk? How can we increase safety factors? We try to stay out of the political side of things, but we can't, because this is a politically charged issue. And despite the fact that we try to keep the focus on victims' rights, it tends to spiral out of our control in that way. So with all of that said, I would always welcome any of you to reach out to the coalition and find out more about this work with victims and survivors of domestic violence as it relates to firearms in our state. And I'm happy to entertain any questions, now or after my fellow panelists talk here in just a few minutes. So, thank you.
Dean Williams.
Thank you. Thanks for the invitation. It's really great to be here. It's great to see Professor Miller after all these years, and it's really wonderful to be here at Duke. My talk's going to be very different. It's based on a paper that I wrote. In which I decided to take a look at the Second Amendment because I felt frustrated in reading cases like McDonnell and Heller, in which the majority of the court talk about the Second Amendment right in terms that to my mind, they didn't talk about other rights. To my mind, those cases suggest that the Second Amendment right to keep and bear arms is elevated above all other rights. And I wondered why. Why would the court do this? Because I could think of all kinds of situations in which the court, they're balanced. There are different things that we take into consideration in terms of when someone is exercising a right. And the thing that came most to my mind, of course, is looking at another non-controversial issue, reproductive rights. So what is it? What is it that, why does the court treat this right differently? Why is this issue so charged? And I decided to take I'm a critical race feminist. So I took a view that we called social justice feminism to examine the Second Amendment. And social justice feminism is a kind of feminism that I heard about from feminist legal advocates. In fact, they said, I don't want to do social justice I don't want to do feminism anymore unless it's social justice feminism. My colleague, Kristen Kalsum, and I decided to figure out, well, what do they mean by social justice feminism? And we determined that social justice feminism is about uncovering and dismantling social and political structures that support patriarchy while recognizing and addressing multiple oppressions. So Martha Shamalis has called it a new take on intersectional feminism. So we're looking at feminism as it intersects race, class, and all other types of oppression. And so where feminist legal theory typically asks the woman question, that is how a particular law or policy affects women, social justice feminism goes beyond that. It embodies three core methodologies. One is looking at history to understand subordinating structures. Two is examining the interrelationship between interlocking oppressions. And finally, focusing on bottom-up strategies. So we're looking at history. We're looking at how does sex intersects with race, intersects with class. And we're also looking at what people on the ground are doing. And I applied these first two methods to District of Columbia versus Heller and McDonald versus Chicago. The majority of the justices in those cases relied on the amendment's history to find that the Second Amendment provides an individual right to keep and bear arms. I also looked at the historical context from which the amendment emerged, but I included the racial and gender implications of that history. And I concluded that the Second Amendment should be understood as playing a role in constructing the concepts of nation and citizen, as well as a social hierarchy in which white men would be at the top of both. In this sense, the Second Amendment also plays a role in constructing race and gender. So first I looked at Heller. You remember, I'm sure you all do, that in Heller, the court's focus was on the words of the amendment, and it broke down the text to a prefatory and an operative clause. The prefatory clause, a well-regulated militia. According to the court, that clause supports the right to bear arms because historically, tyrants suppressed political opponents by disarming them or enabling a militia. But when I applied social justice feminism, I observed two interrelated structural purposes. The first was protecting against tyranny from a central government. The Second Amendment is one of several provisions that limits the ability of the central government to establish and maintain a standing army. The colonists didn't like standing armies. For them, they'd be staffed by professional soldiers who they considered to be guns for hire. So those folks lacked loyalty to their communities or the localities that they purported to serve. And so the term militia is supposed to signal a limit on the centralized government, as well as a definition of who deserved and was expected to serve in that regard, white males. And that leads to structural purpose number two, constructing race and gender hierarchies. And here I wanted to turn to the phrase, the right of the people, to ask which people the framers envisioned. And it turns out that similar to militia service, keeping and bearing arms was a privilege afforded to certain people. Historian Alexander de Conde writes that in England, access to firearms was limited to gentlemen. And that tradition traveled across the ocean with the colonists. And so in the New World, the wrong men were Native and Black. So for example, in Virginia, the law punished selling or trading firearms to Indians with property forfeiture or even death. An 18th century Virginia statute barred Black and Native men from serving in militias unless they were servile labor, that is, drummers or trumpeters or serving people, okay? By excluding Black and Native men from gun ownership, the legal regime signaled who was fit for protecting the state and communities and who was not. And in so doing, the regime deprived Black and Native men the markers of masculinity and its privileges. And so it rendered them like dependents, that is, like women and children. So framers had to be aware of this legal regime. This was something that they were operating, a context within which they were operating. Fast forward to the 19th century and the court's opinion in Dred Scott, and there's language that confirms it. In concluding that the framers never intended to make African Americans citizens, Justice Taney remarked on the absurd implications of such a notion. Quote, "It would give to persons of the Negro race the right to keep and carry arms wherever they went, and inevitably produce discontent and insubordination among them, endangering the peace and safety of the nation." Turning next to McDonald, in which the court examined the Reconstruction era to hold that the Second Amendment applies to state governments, the court focused on white attempts to disarm newly freed Blacks to support its conclusion that the right applies to individuals for self-defense. But social justice feminism reveals that more was at stake. True enough, the enactment of the 14th and 15th Amendments and implementing legislation sparked violent resistance among Southern rights. Commentators have explained that the Civil War loss was a humiliating blow to white men. With emancipation, Black men no longer were dependents, and white men no longer were the lone heads of households, ruling over property, human and otherwise. And improving Black men's status was deemed as a demotion for white men. And so the former Confederates turned to laws and violence to counter Black progress. They enacted slave codes to constrain African American freedom. And these codes included laws that prohibited Blacks from buying, owning, or using firearms. States also forbade Blacks from serving in militias and voting, reserving these in two important markers of citizenship and masculinity for white men, just as was true before the Civil War. With the Reconstruction Amendments, Congress overturned these Black codes, extended the voting rights, and made birthright citizenship explicit. White Southerners also turned to violence and terror to return to the status quo ante. As militiamen, some still in their Confederate uniforms, they targeted newly freedmen and Republican office holders. Congress temporarily disbanded the militias in certain states of the Confederacy to protect both, in the face of arguments that doing so violated the Second Amendment. Federal lawmakers argued in return, though, that they had to do so to quell the continuing Southern rebellion. When the violence didn't abate, Congress acceded to Republican requests to repeal that legislation, making the way for Black militias. And the combination of armed Black men protecting the state and voting, in addition to their new status as autonomous actors, made matters even worse. It repudiated the antebellum social order and threatened white patriarchy. White supremacists redoubled their efforts to vindicate the notion that the United States was a white man's country, and groups like the Ku Klux Klan emerged. They had different names, but I'll call them the Klan, just for simple purposes of simplicity. And their purpose was to protect, quote, females, friends, widows, and their households. And one of their strategies was disarming the Black militia and preventing Black men from exercising their right to vote. And a representative incident is one that happened in Hamburg, South Carolina. The triggering event happened on July 4th, 1876. You'll notice that's the nation's centennial, and it was an election year. Black militia soldiers were drilling in anticipation of a parade until two white men spotted them, Thomas Butler and Henry Getson. These two men were outraged by the sight of Black men armed and in uniform, and to make matters worse, celebrating July 4th. They had no right to do any of those things, in their view. And so the white men claimed that the Black soldiers were trespassing, and they blocked their way. And they claimed that their wagon had worn ruts in the road, making it theirs, that the Black men were trespassing. The soldiers refused to move, And Butler then, as a result of the impasse, went to get his father, a former Confederate general, M.C. Butler, seeking retribution. General Butler, for his part, went to court and he sought to have the black soldiers arrested, claiming that these men had broken the law by possessing firearms, by obstructing the road, and by rioting. Neither the militia commander, Doc Adams, nor any of the officers appeared in court. Instead, they barricaded themselves in the armory, getting ready for the violence to come. General Butler assembled a posse. White residents got wind of what was going to come, and they fled. The battle started at 7 in the evening and lasted until 1 in the morning. And after it was over, the posse had captured 29 men, killed 5 of them after shooting them when they attempted to escape. And reports of the time say that Butler's men dismembered the decedents and paraded their remains to bystanders, including the men's children. Then South Carolina Governor Chamberlain sought assistance from the federal government. And President Grant stated that this massacre was outrageous, but sadly not uncommon. Indeed, the Congress held hearings about such outrages around this time period, but really nothing happened. And indeed, M.C. Butler went unpunished. He later was elected to the United States Senate in 1877. So what do you make of all this? What do we make of all of this? Well, here's a few things. Black exercise of their rights was construed as illegal and a threat. White attempts to disarm blacks was about reconstructing the nation as white and reinforcing white supremacy. Whites alleged self-defense to justify disarming blacks. The self they were defending was the antebellum concept of nation and citizen. The freedmen also asserted a right to self-defense, and it was their newly enfranchised and legitimized citizen self. The last thing I'll mention is there was a question that Professor Miller asked, which is, what can we use? How can this perspective give us any traction in this area? A few thoughts I had include the following, that the Second Amendment remains deeply tied to contested notions of nation and citizen, which helps, I think, to explain why there's so much heat around the issue. Gun ownership and their use have never been unfettered. That's an important point to take away, but they are contingent upon race and gender. When we look at guns in the Second Amendment, I would also suggest we need to be thinking about the racial and gender dimensions. And the epidemic of mass shootings has finally put those issues on the table. As California Governor Gavin Newsom asks, quote, why does it have to be? Why is it men dominantly always? He might have modified that question to include race because in the context of mass shootings, it is usually white men. And the other gender dimension here is the connection between mass shootings and domestic violence. The Washington State Institute for Public Policy and the Center for American Progress have both found such a link, that mass shooters practice their aggression on intimate partners before moving to acts of terror encompassing more people. So if we see the gender and racial roots of gun culture and resistance to gun regulation, we can take steps, albeit incremental, to challenge both. Thank you.
Thank you. Right.
Thank you. It's great to be on this panel and to join Dean Williams and Sherry. So I will be speaking on the issue of guns and domestic violence from the international human rights perspective. And this is partly coming from some work that the International Human Rights Clinic has done on this issue for the last several years in partnership with Amnesty International, including with a couple students who are in the room who've been working on this project very helpfully. So I wanted to start off by sharing some data with respect to guns and domestic violence to sort of set the stage for the issue that we're talking about, and then turn to how we address these issues and what specifically an international human rights framing can bring to a discussion about guns and domestic violence, especially as we advocate for changes to be made to these gun laws and policies. So a little bit of data on this issue. First is that guns are the most frequently used weapon in fatal intimate partner violence against women in the US. In an average month, 50 American women are shot to death by intimate partners, and many more are injured. From 2001 to 2012, of all the women killed by intimate partners, 55% were killed with guns. The second statistic is something that Sherry also mentioned, but I think is worth repeating. It's something that strikes me every time I read it, which is that the presence of a gun in domestic violence situations increases the risk of intimate partner homicide for women by 500%. Guns are also often used in non-fatal intimate partner violence against women with significant, often lifelong adverse consequences. For example, about 4.5 million women have had an intimate partner threaten them with a gun, and nearly 1 million have been shot or shot at by an intimate partner. Guns are also prevalent in workplace homicides among U.S. women perpetrated by intimate partners. So in workplace homicides among U.S. women between 2003 and 2008, nearly 80% of the personal relations homicides were perpetrated by an intimate partner, and firearms were used in a high percentage of these homicides. And there's a lot more data on these issues. I just wanted to share a few of these statistics. So moving from this very sobering data about guns and domestic violence, how do we go about advocating for change? And how do we pressure the US government to change its laws and policies with respect to guns and domestic violence? And specifically, what does an international human rights law perspective bring to this discussion and to this advocacy? And what this framework allows us to do is to show that the US is violating its international human rights obligations when it comes to guns and domestic violence. So how do we do this? First is that in advocating for changes to laws and policies on firearms, the human rights framework can provide an additional framing. So when talking about guns and domestic violence, we're obviously talking about the private sector, right? So private actors, violence that happens within the home. And so how are we able to hold the US government accountable for something that happens in the privacy of the home? And the answer is that under international human rights law, governments have what we call a due diligence requirement, which means that governments must protect individuals against human rights abuse, even by private actors. So there's no requirement that law enforcement or police or government actors have to be involved. And what this means in practice is that governments, including the US, must first prevent gun violence in domestic violence situations. When the violence occurs, they must take steps to investigate and prosecute perpetrators. And they also must assist and protect victims, including by ensuring remedies. And so this framing of using the due diligence requirement under human rights law allows us to demand US government accountability for violence, including that committed by private actors. A second way in which the human rights framework can be helpful in our advocacy around guns and domestic violence is that it allows us to draw on international human rights obligations and treaties that do carry binding legal obligations. So the US has ratified a couple of key human rights treaties, including the International Covenant on Civil and Political Rights and the Convention on the Elimination of All Forms of Racial Discrimination. The US has also signed but not ratified several treaties that are relevant for this issue in particular, such as the Convention on the Elimination of All Forms of Discrimination. And there is a distinction between ratification and signing, but even if the US has only signed these treaties, the government still has obligations. And so being able to use these treaties that the US is bound to and that contain a series of different rights guarantees allow us to bring pressure to bear on the US government. The human rights framing also allows us to address a full range of impacts that firearms have on different aspects of individual lives who are impacted by guns in the domestic violence context. So I want to talk through a couple of these different impacts and how they tie to very specific human rights obligations under these treaties. First is that under all of these treaties, there is an obligation of the government to ensure non-discrimination and equality. And when it comes to the use of guns and intimate partner violence, there is a disproportionate impact on women. So between 2006 and 2014, an average of 760 Americans were killed with guns annually by their spouses, ex-spouses, or dating partners. And out of this total number, nearly 75% of victims were current wives and girlfriends. So we see the really disproportionately high number of women who are impacted in these domestic gun violence situations. We also make the argument that the US government is in breach of its obligations to ensure the right to health and security of person by not putting into place particular laws with respect to guns and domestic violence. And that the government has an obligation, again, under its treaty obligations, to protect life, especially in the case of individuals who are especially vulnerable because of domestic violence. So Sherry made some reference to some of the laws with respect to guns and domestic violence. And one of those laws at the federal level is that an individual who has a permanent restraining order against him, I'll say him here because of the disproportionate impact of violence on women, or who has a misdemeanor domestic violence charge, is not allowed to purchase firearms. There's no requirement under federal law for relinquishment of weapons. So if you have a domestic violence situation and the abuser has a misdemeanor for domestic violence, they can actually, under federal law, hold on to any existing firearms that they might own. And so we make the argument that very logically, the perpetrator of violence would still be able to use the firearms in their possession to commit violence against their domestic violence, their partners in the domestic violence relationship. And that this would violate the US obligation to ensure the right to life and to protect the right to life of those who are most vulnerable. A second example of this under US federal law is what is often called the boyfriend loophole, which you might have heard of, which is that laws restricting access to firearms do not cover people who have dated or are currently dating, unless certain other requirements are met. And so, again, we would make the argument that by not protecting domestic violence victims in this relationship, that the US government is in breach of its obligations. This is especially the case given that between 1980 and 2008, close to 50% of those killed by intimate partners were killed by dating partners. Another right that's implicated is the right to health. So even for those individuals who survive gunshots, they often face a lifetime of very serious health consequences, both physical as well as mental. So with mental health consequences, we see, for example, post-traumatic stress disorder, and that often these conditions are left untreated and even undiagnosed. We also see the ways in which this right to health impacts not only the direct victims of gun violence, but their families as well. So for example, children who are witness to the gun violence, family members who end up taking on caretaking responsibilities as well. And another rights violation that we would bring attention to is the right to work. Again, something that is guaranteed in many international human rights treaties. And the fact that women who are harmed by gun violence in a domestic violence situation might lose their jobs or have lost or reduced wages following a gun injury. And again, here we would look at the indirect victims, so the ways in which family members might have to take on additional financial obligations. Another way in which the human rights perspective and framework can be helpful in advocacy around guns and domestic violence is that it allows us to bring in a comparative piece from other countries and to demonstrate best practices on firearm regulation and violence prevention. So while the fatal use of guns against women is a problem everywhere, it's particularly stark in the US. Women in the US are 16 times more likely to be killed with guns than women in other high-income countries. So with this, again, we're able to show that similarly situated countries elsewhere that have different laws and policies on guns have much lower rates of gun violence, including as it connects to domestic violence. Another benefit of using the International Human Rights Framework in this context is that it allows us to use certain underlying principles of human rights, so one of which is intersectionality, which Dean Williams also spoke about. And domestic gun violence is indeed intersectional. For example, in 2017, which is the most recent date for which we have data, Black females were murdered by males at a rate that was more than twice as high as white females. And so this intersectional approach allows us to show the disproportionate and different impact of domestic gun violence on racial minorities, immigrant women, and LGBTI populations. The Human Rights Framework also requires that the government collect data, including disaggregated data. And we find with the issue of domestic gun violence that comprehensive data that analyzes the rates of domestic gun homicides, specifically among racial minorities, LGBTI populations, and immigrant communities, is very much lacking. And so under a human rights framework, we would argue that the US government must collect this disaggregated data to better understand how differently situated individuals and communities are impacted by these laws, and to then use this data that's collected to inform policy changes. And another benefit of the human rights framework is that it can broaden and diversify the groups and sort of category of advocates that work on this issue. So, for example, the Human Rights Clinic submitted to the UN Human Rights Committee a report this spring. So the US government, as I mentioned earlier, has ratified this International Covenant on Civil and Political Rights. And as a result, must come before a UN committee that monitors the extent to which the US is in compliance with this treaty every couple of years. And US government officials have to appear before this committee and answer questions about their extent of treaty compliance. And so we as a clinic submitted this report outlining the ways in which, from our perspective, the US government is in breach of its obligations under this treaty for its failure to protect victims of domestic violence. So this is a very sort of official intervention and a way to get this information before an official UN committee. And when the US government now comes before this committee, some of their questions will be based on the points that we brought up in our report. So it really allows us to engage with a range of important stakeholders, including UN committees and different UN independent experts. It can also be useful in the sense that groups in the United States who are working on this issue are not necessarily bringing a human rights framework to the advocacy. So the clinic students and I attended a conference in Denver earlier this year that was made up almost entirely of social movements, grassroots groups, and civil society groups working on gun violence, including, for example, the students from the Parkland shooting and other families of impacted individuals. And we were able to contribute this international human rights framework to some of the advocacy that they're doing, which is something that they were very receptive and open to, given that it's sort of an additional tool that they can use in their advocacy, given that it can also often be an issue that it's difficult to get traction with, that they were very welcome to using a potential additional advocacy tool. The final benefit of using an international human rights framework in this area is that it allows us to recommend a broader range of different remedies. So governments are required to provide an effective remedy for gun violence victims. And in constructing these remedies, human rights law requires that states must be responsive to individual circumstances. So for example, going back again to this issue of intersectionality, given the adverse impact of policing in many communities, including migrant communities, immigrant communities, and other communities, a human rights compliant remedy would not necessarily call for an increased role of law enforcement in these communities, where there is often this difficult relationship with law enforcement. But instead, we would try to think about more creative ways to engage with community members in a way that, sort of echoing this bottom-up idea, would also be listening to what it is that victims of domestic and gun violence would be asking for. Thank you.
Thank you so much. So we've got about 15 minutes. We've got, I'm sure, lots of really good questions out there, and I'll manage the queue. Anybody want to direct a question to any of our panelists, any single one, or to them all?
I'll start.
All right.
So I have a question for Sherry. How often in the agency's advocacy or your talks around the state, does the pushback that you get come from legalistic arguments about what the Second Amendment means, and how much of it is a cultural, anything that you do around guns is a violation of my Second Amendment rights? To what extent is it on doctrine or like what the Second Amendment means in a legal context, and how much is it like cultural pushback?
That is a great question. It was actually something I was thinking a lot about this morning as I was preparing to come over. I'm not hearing the argument framed as academically. So in the Heller opinion, which I've reviewed again in preparation for the panel, I was thinking about this very thing, that we don't often hear about, the legalistic history of Second Amendment rights, and Dean Williams, sort of outlined how some of that has played out in history. That's not the argument that I'm hearing, and in fact, it seems like a lot of the pushback that we get is very, very much along gender and racial ideals that are not necessarily stated as much, but the idea of protecting my home and hearth, and I've got to be armed in case there's an intrusion in my family, sort of responsibilities that are highly, I would say, gender normed from the folks that we're hearing them from. Does that answer your question?
I was wondering, my question is for Ms. Williams. Specifically, when you were introducing your topic, you were talking about how the Second Amendment right has been framed differently than other rights. And I was wondering, kind of in operation, like how does that look? Like, what does it look like for this right to be defined differently? Like, what specifically are they saying that's different from other rights?
Well, I'm thinking about in the court's description of the Second Amendment right, there's a reluctance to regulate, and Justice Thomas, for example, recognizing, of course, that he's writing in concurrence, but he suggests that the Second Amendment, in fact, I think he even says the Second Amendment right is the right upon which all other rights are based, and that our nation would, rest upon that right. And so he says that in a way to suggest that the right should not be regulated. It should be, the regulation should be very limited. And I've yet to see a case in which the court articulates ways in which how regulation would be accomplished. What are factors that would come into bear to determine whether or not the state had interfered with the Second Amendment right? These are standards that we see in the context of the First Amendment, for example. We know we have a First Amendment right to free speech, but it's not a right that is without limits. And there's a very robust doctrine about when states can and cannot regulate the right to free speech. To date, we don't really have that when it comes to the Second Amendment, and that's what I'm referring to. That it's not occurring in the doctrine and in the rhetoric, which, granted, is not the doctrine that courts have to abide by. The rhetoric suggests that you can't take our guns away. That any type of regulation is one that represents an incursion on the right. And my response to that would be that, history suggests, and this is a history that the majorities in both Heller and McDonald didn't talk about, that there have been regulations. And indeed, your Center for Firearm Regulation has like a wealth of laws that show that the states had been regulating gun ownership from the beginning of our republic. So to say that it can't be regulated is simply not true. So that's what I was referring to. I wanted to actually say something as well about the home and hearth and the gendered nature of that. I mean, I think your question, what's interesting about that question is what happens when the person living in the home is the person who's at risk. Mm-hmm. And here I think about stand your ground laws. And when I wrote this paper, one of the issues that was rolling around was a woman named Marissa Alexander. She happened to fire a gun to warn her husband, who'd been abusing her, not to hit her anymore. And at trial, she was on trial for aggravated assault. She asserted a stand your ground defense. She was in Florida. And the court said she couldn't assert that defense because she was in the home and he was in the home. And because her husband had a right to be in the home, she had no right to assert the defense. And that case was contrasted to the case of Trayvon Martin, who, as you know, was killed because stand your ground applies everywhere else. So there are lots of states for which the home is not safe, and the reason that Sherry's hearing that you have to have guns to protect yourself won't necessarily apply to people being battered because they equally have the right to be in that same space. And I don't know of a way that the law has figured out how to address that, other than to say, well, she has a duty to retreat, but where shall she go? She's already in her home. This is a way in which the gender notions of, it's called the castle doctrine. So man's home is his castle. The battered person doesn't have that same right. This is an area that needs to be addressed as well. So it doesn't seem to, if they're saying that is the reason, that's just all the more reason to be concerned.
Other questions? Jesse?
So, from an international standpoint, I'm trying to figure out for violations of America's, I guess, signature on this international agreement, what are the remedies that can potentially happen? Because one of the things that just sticks out in my mind is we have situations that are fairly recent where police officers are killing people who look like me in their home for no reason at all. And I think that we are beyond trying to figure out how to get Congress to act. So I'm wondering, is there anything on the international scale to make America?
Yeah, so a lot of the work, I think for that exact limitation in the sense of the federal government failing to act on these issues is that we've seen quite an upsurge for this issue, the issue you mentioned in terms of police violence more broadly against people of color and other human rights issues, for really local advocates to take up these issues at their local government level, city government level, and state government level. So under international human rights law, even though it's the federal government that has signed and ratified these treaties, the obligations do extend to all levels of government. And so I think, particularly with the gun violence issue, where we've seen such an increase in social movements who are working on these issues, we have seen examples where they are bringing some of these human rights framings and arguments to their local advocacy efforts. And I didn't go into details about some of the state laws, but there are some key examples of very favorable state laws when it comes to guns and domestic violence. And so, for example, in the submission that we made to the UN Human Rights Committee, as some of our recommendations included positive examples from states that do have more human rights compliant laws and policies in place. And arguing for, first of all, for additional states to adopt these laws, but then also eventually for the federal government to also make changes that are more human rights compliant in that sense. And I think with human rights law, it's always, it can be a slow process, but I think just the fact that local advocates are incorporating this more into their advocacy, again, at the very sort of hyper-local level, is something that is potentially positive in this area. And actually, just to add to that as well, that it can also be a way to link with advocates in other countries. So around the issue of police violence, for example, we've seen examples of groups in the US that are linking up with social movements abroad that are also facing similar issues and sort of being able to borrow strategies and advocacy tools from one another.
So I've heard a few times you all talk about the federal statutory scheme, and it looks like in the scheme that anybody who's convicted of a misdemeanor crime of domestic violence is prohibited from transporting or possessing a firearm or ammunition. So what's the disconnect between a prohibition on possessing a firearm and having to surrender that firearm? Like, why doesn't that just solve the issue here?
In other words, why doesn't the possession also include the relinquishment?
To surrender.
We would argue that it should. But yeah, the language is very specific, that it's possession, transport, and sale, I believe. And speaking of states, there are some states that do have relinquishment laws, but it's not in the federal law, and it's a minority of states that have that requirement. And so yeah, we would exactly argue at that point that if the goal of prohibiting possession is that the person shouldn't be allowed to own them, that should also include guns that are already owned, right? So that would be an exact logical conclusion that is unfortunately absent in the law.
And I would just add to that when you are thinking about this issue, of who is responsible, who's the state arm for enforcement, or the state and federal governments, we rely heavily on local law enforcement agencies for enforcement of federal law, and it just doesn't happen. And we have, over 400 municipalities, individual municipalities in local governments in North Carolina, each of them doing things completely differently and separately from one another. So there's really just not one uniform set of laws that act as an enforcement mechanism for relinquishment or confiscation. It's not there.
See a lot more legislation that takes into account mental health. Is there becoming like an integration between those? Because a lot of times abusers in the situation exhibit signs of like mental health. So is there like a push to integrate that legislation into just kind of domestic violence possession as well?
Well, in North Carolina, House Bill 454, which I mentioned earlier, was our version of an extreme risk protective order, which was introduced by Representative Morey this year. I think it's a separate statute, but what we did do is I sat down with the groups that were advocating for the sponsorship, and we looked to make sure that the two statutes would be compatible. In other words, it wouldn't set up dual processes that a victim of domestic violence would have to go through both of them in order to secure the surrender of a firearm. And I think we did that with some success, but they weren't the same. It wasn't incorporated into existing domestic violence firearms law. It was its own standalone. But I do think it's wise anytime you're working on the mental health issues and extreme risk protective orders to get all the stakeholders involved and make sure that you're not inadvertently working at cross purposes or setting up, overly burdensome processes.
So I'm going to take moderator's privilege and ask a somewhat, I think it's a question that needs to be asked, even though I haven't sort of previewed it for you, because in a case called like Katana, which you might be familiar with, the Supreme Court uses a woman suffering from domestic violence as the kind of, look, this woman's being denied the right to have a weapon to protect herself. It's a case that the Supreme Court of the United States said that you have a right, that the analysis at the Massachusetts Supreme Judicial Court was wrong in terms of figuring out whether a taser was an arm that was protected by the Second Amendment. And there's a slice of individuals like Justice Alito and in his opinion that will take up this, but say, yeah, and the reason why we have gun rights is for the protection of women, not necessarily for their exploitation or harm. And I'm just kind of curious about, I have to believe that each of you have encountered that sort of counter argument, especially in the legislative sphere. And what is your sort of best account or best counter to that kind of narrative about gun rights and its intersection with domestic violence?
Well, my response to that, as someone who served victims directly for 10 years, is very anecdotal and not at all, backed by any research. But I just really encountered one victim in 10 years, and probably I'm going to estimate, 800 different cases I worked on who actually took the step of going and securing a pistol permit for herself as a means of protecting herself. My observation, again, not backed by any research whatsoever, is largely that is not an option that most of the victims that I have worked with have been turning to. I think that it's an appealing argument for gun rights advocates to make, in that it sounds very empowering for survivors of domestic violence, and I certainly wouldn't, I wouldn't want to disempower a survivor who was looking towards that as an option, and for whom that was the last means that they felt they had of protecting themselves. I did not observe that being an overwhelming response to the survivors that I worked with on the whole for protecting themselves. Not to say it doesn't exist.
Well, I would just add, as I mentioned before, the stand your ground, I think a woman in that situation might find herself not really being able to avail herself of that type of defense. If the person, her cohabitant, was somebody who was authorized to be in that location. So that's one problem. The other problem, I remember there are other jurisdictions where when police, in Cincinnati is like this, when police show up to a place where there's a domestic violence disturbance, and the woman says, my boyfriend's been beating me, and he says, well, she's been beating me too, that they arrest both of them. And so, because they say, well, we can't make a determination, and I forgot the name of there's a name for this.
Predominant aggressor.
No, that's not it. But that, that you have that happening as well, so that the abuser who is, let's remember, this is about power, it's about control, it's about manipulation, that abusers are not beyond manipulating law enforcement. And so they will come up with reasons that will undercut whatever reason it is that the survivor is using to justify her use of her hands or whatever weapon that she has. So I think, and then the third thing is, I just share your feeling like, more guns is not the answer to more guns, it seems. This is not the wild, wild west. Right.
Yeah, I'll just sort of add on that point in terms of determining who the aggressor is versus the person defending themselves. Is we had somewhat of a focus on Louisiana in looking at this work, and there were a couple of documented examples where, for example, in lesbian and gay relationships, when the police showed up, they would sort of make an assumption based on who looked to be sort of the more dominant member of the relationship, and automatically arrest that person without listening to the people who were involved about, again, if there was one person who was defending themselves, one was the aggressor. And similarly, in immigrant communities where, for example, if one member of the relationship is able to speak English and the other person isn't, or sort of more used to dealing with power authorities, is a citizen, for example, that power dynamic comes into play as well. And so sort of all articulation on behalf of the person who might be defending herself is lost in the face of that interaction. And so I think that's an additional danger of this issue itself.
In the international rights perspective, to the extent it's putting onus on the government to actually protect, as opposed to say, hey, you're on your own,
You're on your own, right.
Changes the framing for it. Well, with that, thank you very much to the panel. This was an excellent talk. I really appreciate you coming out.